Welcome to LexTalks Legal Topics Simplified,
Ah,
where
yeah.
we break down complex legal ideas and make them a lot easier to understand.
Yeah.
Today, we are going deep into private law review and other remedies.
Okay.
Big topic, lots to unpack. Injunctions, declarations, damage suits.
Hmm.
We're even going to take a look at things like the Lokpal Lokayukta
Okay.
and the Ombudsman.
Yeah.
As law students, this is going to be pretty relevant for you.
Absolutely. These are all really important tools for anybody working in the legal system, especially in administrative law.
Okay, so let's unpack this. Maybe we could start by looking at how these remedies play out, in the Indian context.
Good point. The Indian legal system, it's a lot like the British parliamentary system in that it's built on this balance of power
Okay.
between the executive, legislature, and judiciary.
Hmm.
The executive branch is led by the prime minister and the council of ministers.
Right.
They're accountable to the legislature.
Okay.
So that creates this system of checks and balances.
So no single branch can just kind of do whatever they want.
Exactly. Good example of how this works in practice is the 1999 case of Common Cause versus Union of India.
Okay.
Now, this case revolved around something that might seem pretty ordinary at first, the allotment of petrol outlets.
Wait, hold on. How did petrol outlets become like a legal issue?
Well, the petitioner in Common Cause, they argued that a former minister had misused their discretionary powers when they were allotting these petrol outlets.
Okay.
And they said that violated this principle of collective responsibility of the cabinet.
Interesting.
So it wasn't just about petrol, it was about how the government should operate
Right.
and how they should be held accountable.
Okay. So how does this example highlight the difference between public and private law?
That is key to understanding these remedies.
Okay.
Public law.
Yeah.
It deals with disputes between citizens and the state,
Mm.
while private law governs relationships between individuals.
Okay.
So remedies in administrative law,
Uh-huh.
which is part of public law. They're designed to uphold the rule of law and prevent the state from acting unfairly.
So they're kind of like safeguards against the government exceeding its authority?
Precisely. And what's interesting is how the reach of public law, it's expanding.
Like-
It's even influencing contract law.
Wait, so public law can impact private contracts. How does that work?
Perfect example is Union of India versus A.L. Ram
Okay.
from 1964.
Mm.
This case showed how principles of restitution,
Yeah.
typically associated with private law,
Yeah.
could be applied in a public law setting.
That's really interesting. It really blurs the lines a little bit.
Yeah.
So what are some of the specific remedies available in these situations?
One of the most powerful tools that you have at your disposal as law students and future legal professionals
Yeah.
is judicial review.
Judicial review, it sounds kind of intimidating. What exactly does it involve?
Think of it as the cornerstone of administrative law.
Okay.
It enables the courts to scrutinize
Mm-hmm.
the actions of the executive branch. Okay.
Articles 226 and 32 of the Indian Constitution
Right.
give the high courts and the Supreme Court the power to strike down any executive action
Yeah.
if it's deemed unlawful or in violation of fundamental rights.
If the government makes a decision that seems unjust or illegal, the courts can intervene.
Exactly. And India's judicial review system, it's robust. It actually predates similar systems in other countries.
Really?
Yeah. For example, the English system didn't introduce Order 53, which allowed for damages in judicial review applications until 1977.
Interesting.
India's system was already well established by then.
Okay. I'm starting to see how all of this connects. But
Yeah.
what happens when it's not just about the government as a whole, but about individual officials acting improperly?
That brings us to the very interesting area of torts
Okay.
and public officials.
Okay.
There's a specific tort
Yeah.
called misfeasance in public office
Okay.
that holds officials accountable for intentionally abusing their power.
Okay.
It goes beyond just simple negligence.
Right. It's about deliberate and dishonest conduct.
So if a public official is intentionally acting in bad faith, they can't just hide behind their position.
Right. The English case, Three Rivers District Council versus Bank of England from 1996, very clearly laid out the elements of this tort,
Mm-hmm.
emphasizing that you need to prove this deliberate and dishonest conduct.
I can already see how this applies to the Common Cause case we discussed earlier.
You're absolutely right. In that case, the petitioner claimed that the allotment of petrol outlets was an act of state
Okay.
and thus immune from liability.
Interesting.
However, the petitioner argued that it potentially fell under misfeasance because it involved personal gain.
Okay, so now we need to understand what active state really means. Can you explain that?
Essentially, it's a legal principle suggesting that certain government actions, often relating to foreign policy or national security, are beyond the reach of court scrutiny.
So things like declaring war or signing treaties, those would be considered acts of state. But would allotting petrol outlets really fall under that category?
That's exactly the question the court had to grapple with in Common Cause.
Right.
Was it a legitimate act of state, or was it an abuse of power for personal gain?
Right.
And to answer that, they had to consider how India's legal system has historically approached this concept of government liability.
So how has that concept evolved over time? Did the government always have this kind of immunity?
It's been an interesting journey. Initially, the government of India, they enjoyed this broad immunity from lawsuits.
Okay.
Similar to the idea of sovereign immunity you see in other countries,
Yep.
this stemmed from British rule where the crown was largely immune from legal action.
So in those early days, if the government wronged you, you had very limited options for seeking justice.
That's right. But things started to shift with the Government of India Act of 1858,
Okay.
which allowed the government to be sued.
Okay.
In certain cases, it chipped away at that absolute immunity. And later, the acts of 1915 and 1935, they continued this trend of allowing lawsuits against the government in certain circumstances.
It sounds like a gradual movement towards greater accountability. Did this continue after India gained independence?
Absolutely. The Indian Constitution of 1950 directly addressed this issue.
Okay.
Article 300.
Mm-hmm.
It states that the government can be sued in similar cases
Okay.
as it could have been before independence.
So the Constitution didn't completely overturn the old system, but it did establish a framework for holding the government accountable in certain situations.
Exact.
But how did this all play out in the Common Cause case?
Well, the court in Common Cause, they had to consider a series of precedents to figure out if the minister's actions were immune as an act of state. One key case they looked at was Amistad Vivadi versus State of Punjab from 1967. In that case, the Supreme Court, they awarded compensation to a widow
Okay.
whose husband was killed due to the negligence of a government employee.
So it wasn't just about holding the government itself accountable, but also its employees.
Precisely. However, there was another case
Okay.
that seemed to contradict this.
Okay.
Kasturi Lal Ralia Ram Jain versus State of Uttar Pradesh from 1965.
Okay.
In this case, a businessman's gold was seized by the police and then it later vanished. But the court denied him compensation.
Wow.
They argued that the police officers were acting as agents of the state while exercising sovereign powers.
So in that case, the act of state defense worked. How did the court in Common Cause resolve these seemingly opposite rulings?
They distinguished custody law by saying it involved tortious liability arising from the exercise of sovereign power. They argued that the allotment of petrol outlets didn't fit into that category.
It seems like the key question was whether the government action was inherently a function of the state or something that should be judged by the same standards as actions by individuals.
You've hit the nail on the head. The Common Cause Court, they favored this narrower interpretation of act of state.
Okay.
Essentially, they were pushing for greater accountability for actions that fell outside the core functions of the government.
Right. So it wouldn't be fair to just let the government evade responsibility just by claiming act of state for any action that harms citizens.
Right. The court seemed to be drawing a line emphasizing this need to differentiate between legitimate acts of state and instances where officials might be abusing their power.
This is all incredibly fascinating. I'm already seeing how these legal concepts play out in real-world scenarios.
I'm glad you're finding it engaging. But there's still much more to explore. Remember, we've just scratched the surface here.
Yes, we still have a lot more to unpack. I can't wait to dive deeper into these remedies and see how they can be used to ensure justice and fairness.
We'll pick up right where we left off in the next part of our deep dive.
Welcome back to LexTalks. Last time we were talking about that Common Cause case.
Right.
And how the court had to figure out if the minister's actions in allotting those petrol outlets were an act of state or misfeasance in public office. So where did they land on that?
It's a crucial point because the petitioner's argument was that the minister was using their power for their own personal gain.
Okay.
So the court ultimately decided those actions weren't a legitimate act of state.
Right.
But that doesn't automatically mean that misfeasance was proven right.
Right. Didn't they have to prove that the minister, acted deliberately and dishonestly to make that misfeasance claim actually stick?
Exactly. It's not enough to just show that the allotments were improper or maybe not the best.
Right.
You have to demonstrate intent.
Yeah. Proving someone's intentions, that's got to be difficult.
You're right. It's really tough to do. But the court, in common cause, they relied on a few key pieces of evidence
Oh, okay. What kind of evidence?
to support their finding of misfeasance. Well, for one thing, the minister had given out petrol pumps to several people who were clearly ineligible
Oh, yeah?
based on the existing guidelines. This included relatives of the minister's staff, sons of oil selection board members, even board members themselves.
So they were giving it to, all their friends and family?
Pretty much. It's hard to believe those were just innocent mistakes.
Right. It seems a little suspicious.
Yeah. The court saw this pattern as strong evidence of intentional misuse of power.
So it wasn't just a single instance. It was a whole pattern of behavior that pointed to something more deliberate.
Exactly. And to make matters even worse,
Yeah.
the minister didn't provide clear explanations for these questionable allotments.
That's not a good look.
No, it's not. It's like that saying, if you've got nothing to hide, why hide it?
Right. Exactly.
Now, to really nail down their reasoning on misfeasance, they referred back to a landmark English case.
Okay.
Three Rivers District Council and Ors v. Bank of England, number 3, from 1996.
That's the one that established the definition of misfeasance in public office, right?
Yes. It stated that misfeasance involves a deliberate and dishonest wrongful abuse of the powers given to a public officer. And the purpose of this tort is to compensate those who were harmed
Okay.
by that abuse.
So it's not just about, punishing the official. It's also about, making things right for the person who was wronged.
Right. But here's where it gets a little interesting.
Okay.
That Three Rivers case also clarified that proving malice, meaning intent to harm the specific plaintiff,
Right.
isn't always necessary for misfeasance.
Wait, so if it's misfeasance, shouldn't there be bad intentions? That seems kind of counterintuitive.
It does seem that way. But the Three Rivers Court explained there are 2 ways to establish misfeasance.
Okay, I'm listening.
The first one, which is the more traditional way, involves proving that the official acted with malice,
Okay.
meaning they intended to injure the plaintiff
Right.
or someone in a similar position.
So if an official deliberately targets someone, out of revenge or spite or something, that would be this category.
Exactly. But the second one is more about recklessness.
Yeah.
You have to prove that the official knew they didn't have the authority to do what they did and that their actions would probably harm the plaintiff
Right.
or someone in a similar situation.
So even if they didn't have this specifically malicious intent, if they just knew it was wrong and harmful, they could still be in trouble.
Precisely. So it kind of broadens the scope of misfeasance to situations where an official acts with a blatant disregard for the law and for the consequences.
Right. So the court is saying, we're not going to let you off the hook just because you weren't, twirling your mustache.
Exactly.
If you knew what you were doing was wrong and you did it anyway, you're still responsible.
It's a great way to sum it up. And this approach really reflects this growing emphasis
Okay.
on holding officials to a higher standard.
Now, going back to the common cause case, which of these paths did the court use when they were analyzing the minister's actions?
They didn't explicitly say which path they were following, but their reasoning kind of suggests elements of both.
Okay.
They emphasized how the minister disregarded the guidelines for giving out petrol pumps and how they showed favoritism towards individuals connected to them.
It sounds like they were saying, look, these actions, they went beyond just a simple mistake or negligence.
Right.
This was a knowing violation of the rules.
You got it. While they didn't explicitly say the minister acted with malice toward the petitioner,
Right.
their findings point to this blatant disregard for the law
Right.
and the potential harm that could result.
So what happened to the minister? Did they get hit with those exemplary damages?
Interestingly, no. While they found the minister liable for misfeasance, they decided against exemplary damages.
Okay.
They said they were concerned about how that might impact government functioning.
I mean, I get it. If officials are constantly worried about facing huge penalties, they might be afraid to make any decisions at all.
It's all about finding that right balance.
Yeah.
You want accountability, but you don't want to create this atmosphere of fear that basically paralyzes the government. Right. So it's like they're saying, you abuse your power, but we're not going to go overboard with the punishment. because we don't want to make it harder for the government to actually do its job.
That's a great way to put it. It's a nuanced decision
Yeah.
that reflects the complexity of government liability.
So this whole case really highlights how these legal principles actually play out in the real world.
It does.
As law students, we learn about these concepts, but it's so valuable to see them in action.
Absolutely. And the common cause case is a goldmine
Yeah.
of legal insights. We've talked about active state. We've talked about misfeasance, the challenges of proving intent. But there's another piece of this case that we haven't really talked about yet.
Okay.
And that is the petitioner's claim that the minister also committed criminal breach of trust.
Oh, wow. So now we're talking about potential criminal charges.
Exactly. This is where administrative law and criminal law intersect.
Okay.
So the petitioner was arguing that the minister using public resources for personal gain,
Yeah.
that's a crime. So it wasn't just a civil issue. It had these potential criminal implications as well. What exactly is criminal breach of trust?
So it's defined in the Indian Penal Code, Section 405.
Okay.
Basically, it's about when someone who's been entrusted with property or authority
Yeah.
dishonestly misuses that
Okay.
for their own benefit
Okay.
or in violation of the terms of that trust.
So like a bank manager stealing money from the bank.
Exactly. But in common cause, the question was, do the minister's actions in misusing their authority to allot these petrol pumps, does that fit this definition?
Yeah, it seems like a more complicated application of that idea. So did the court agree? Did they say that the minister had actually committed a crime?
To understand their decision, we need to go a little bit deeper into the idea of public trust,
Okay.
and especially as it applies to government officials.
So what does public trust mean in this context?
It's a really fundamental principle.
Okay.
In democratic societies, government officials hold their positions and they use their power for the benefit of the public. Not for their own personal gain. They're basically trustees of the public's resources
Makes sense.
and their well-being.
So they have like a moral and a legal obligation to act in the best interests of the people they serve.
Exactly. And this whole idea of public trust has really deep roots in legal and political thought.
You can see how it applies to this common cause case.
Yeah.
Because if the minister was using their authority to just benefit themselves or their friends,
Right.
it's a violation of that trust.
Exactly. And the court in common cause, they leaned heavily on this concept.
Okay.
They referred to a case from 1997, MC Mehta versus Kamal Nath, where the Supreme Court, citing an ancient Roman doctrine, declared that natural resources are held in trust by the government
Wow.
for the public benefit.
So they were bringing in all these like historical and philosophical principles to address this modern legal issue.
Exactly. It shows how interconnected all of this is. But going back to criminal breach of trust, while the court acknowledged this public trust idea, they didn't actually say for sure whether the minister met all the elements of this crime.
So they kind of left it as an open question?
Yeah, you could say that.
Yeah.
They directed the Central Bureau of Investigation, the CBI,
Yeah.
to investigate these allegations of criminal breach of trust
Right.
and any other potential offenses.
So even though the civil case was wrapping up, the possibility of criminal charges was still there.
It was.
Okay, so did the CBI just take the court's findings and run with them?
Well, this is where it gets a little tricky.
Right.
The court told the CBI to investigate, but also told them not to be influenced by any observations or findings made in their judgment.
Wait a minute, so they ordered an investigation based on their findings, but then they said, ignore what we found.
It's a point that generated a lot of debate
Yeah.
and criticism. The petitioner's lawyers argued that this instruction actually weakened the court's findings of misfeasance and this potential criminal breach of trust.
It does seem like a mixed message. On the one hand, they're saying there's enough here for you to look into it, but then they say, but don't pay attention to what we said.
Right. It's a delicate balance.
Yeah.
The court seemed to be trying to balance their role in the civil case while also respecting the CBI's independence.
Right. So you want a thorough and impartial investigation.
Yeah.
But it also seems weird to ignore evidence of wrongdoing that the court has already identified.
It really highlights the tension between judicial oversight and investigative autonomy.
Yeah.
So ultimately, it was up to the CBI to figure this out.
Wow, this case is a roller coaster.
Yeah.
We've seen how it touches on fundamental legal principles, government accountability, and even dips into criminal law.
And we're not finished yet.
Okay.
But first, maybe we can take a minute and just recap the important takeaways from Common Cause.
Yeah, good idea.
Yeah.
We've covered a lot of ground. So what were like the most crucial points?
So first of all, it really showcased the power of judicial review. In challenging government actions, the court's really thorough analysis and their finding of misfeasance,
Yeah.
it really underscores the importance of holding officials accountable.
Right, and they drew on so many different legal concepts. Active state, misfeasance, public trust.
Yeah.
It shows just how complex this area of law can be.
It really does, and it also showed the complexity of government liability in India.
Right.
The Constitution allows these lawsuits, but how courts interpret things like active state can have a huge impact.
We also saw that tension between accountability and effective governance.
Yes.
And that's reflected in the court's decision not to impose those exemplary damages.
Exactly. And finally, raised some really crucial questions about the role of the CBI and the appropriate level of judicial oversight in these investigations.
It's amazing how much we can learn from just one case.
I know, it's fascinating.
And for law students, it's a great way to see these theoretical concepts applied in a real situation.
It really is. And we're not done yet. There's one more piece of common cause that we need to explore, and that's the issue of discretionary quotas.
Okay, discretionary quotas, that sounds interesting. What are those, and how do they factor into this whole thing?
So in common cause, the minister's power to allot those petrol pumps came from this system of discretionary quotas that were given to different officials, including the prime minister, members of parliament.
So the minister wasn't just acting on their own. There was this system that gave them the authority.
That's right. And the Common Cause Court, they actually provided a whole list of these discretionary quotas, and it revealed all sorts of areas where officials could basically make decisions based on their own judgment instead of strict rules.
That seems like a lot of opportunity for things to go wrong.
It does. What kind of things were on this list? Oh, it's pretty extensive.
Okay.
It included things like allotments of petrol pumps.
Right.
Gas agencies, out-of-turn phone connections.
Wow.
DDA flats, even free airline tickets.
Wow. That's a lot of perks. No wonder this system raised some eyebrows.
Yeah, you're telling me. And while the court didn't condemn discretionary quotas entirely, they did express some reservations. They said these quotas might be useful sometimes, but they need clear guidelines to prevent unfair or random decisions.
So it's like giving someone this powerful tool, but not telling them how to use it properly.
Exactly. The court seemed to be saying discretion is sometimes necessary, but it should always be exercised within a framework of rules and accountability.
It's that balance again, which seems to be a big theme in this whole deep dive. Discretion is like any form of power. It needs those checks and balances to make sure it's not misused.
Couldn't agree more. Now, the court, they also drew a parallel to another interesting case that involved Maruti cars.
Maruti cars.
Yeah.
What do cars have to do with petrol pumps and government discretion?
The connection is in how the court addressed regulating that discretionary power. So the Maruti case involved a challenge to the car manufacturer's own discretionary quota for giving out cars. And the court stepped in to create some clearer guidelines.
So they didn't completely get rid of the quotas, but they tried to make the system more fair.
Exactly. They wanted to prevent them from being used for favoritism. And undue influence.
What kind of guidelines did they come up with?
They created a priority system for allotting cars from that quota. Certain groups like defense forces, judiciary constitutional heads MPs.
So they were trying to make sure that people who were in essential positions got priority.
Precisely. And they also pushed for more transparency and accountability, requiring clear reasons for each allotment.
So the judiciary can really play an active role in shaping public policy. And making sure that these discretionary powers are being used appropriately.
It shows that courts can be guardians of justice and fairness. They can shape how laws are applied and even influence the creation of new ones.
This whole deep dive has been incredibly eye-opening.
It's been a journey.
We've seen how active state, misfeasance, public trust, all these legal concepts play out in real-world cases. We've looked at that common cause case, the complexities of government liability, and how to prove intent, and that need for a balance when it comes to discretionary powers.
We've covered a lot of ground.
We have. But we're not quite finished yet. In the final part, we'll be exploring something really interesting. The Lokpal, the Lokayukta, and the Ombudsman. Stay tuned for more. Welcome back to LexTalks. So we're wrapping up our deep dive into private law review and other remedies. And in this final part, we're going to explore these institutions that play a really important role in accountability, the Lokpal, the Lokayuktas, and the Ombudsman.
Right. These institutions, they offer this unique perspective on how different legal systems address grievances
Right.
and uphold ethical standards in government.
Okay, so let's start with the Lokpal and Lokayuktas. We've talked about their origins in India, but can you paint us like a clearer picture of what they actually do?
So think of them as like these independent watchdogs
Okay.
against corruption. They investigate allegations of wrongdoing by public officials,
Oh,
including those in very high positions.
so they're not just going after low-level bureaucrats.
Yeah.
They could even investigate someone like the prime minister.
Yeah, that's right. The Lokpal has jurisdiction over a wide range of public servants.
Okay.
That includes the prime minister, members of parliament, top officials in the central government.
Wow, that's a lot of power. And what about the Lokayuktas? Do they have a similar role?
They operate at the state level,
Okay.
so they investigate allegations of corruption against state government officials.
So it's kind of like a two-tiered system
Right,
with the Lokpal at the national level and then the Lokayuktas in each state.
exactly. And the Lokpal and Lokayuktas Act of 2013,
Okay.
that lays out the framework for how these institutions operate, their powers,
Right.
the procedures they follow, the types of complaints they can handle.
What about their investigative powers? Can they just like walk into anyone's office and demand to see their files?
They have a range of powers. They can summon witnesses. They can demand documents.
Right.
They can even conduct searches and seizures if it's necessary.
So they're not just there for show, they actually have some teeth.
Right.
But what happens if they actually uncover evidence of wrongdoing? Can they punish someone?
So they don't have the power to directly punish anyone. Their role is primarily investigative.
Okay.
So if they find evidence, they'll recommend prosecution to the relevant authorities.
So they're kind of like detectives.
Yeah.
They build the case, but then they leave the actual prosecution to someone else.
That's a great way to put it. And their recommendations carry a lot of weight.
Right.
They often lead to formal charges.
So it seems like India has built this really robust system for tackling corruption
It has.
at all levels of government.
It's a system that has evolved over time, driven by this growing need for accountability
Right.
and transparency.
Okay, so let's shift gears a little bit and talk about the Ombudsman.
Okay.
We said it originated in Sweden, kind of a global thing now. What's the main idea behind this institution?
The Ombudsman acts as this impartial intermediary between citizens and the government.
Okay.
So they investigate complaints against administrative actions, making sure that government agencies are operating fairly.
So if you feel like you've been wronged by a government agency, you can go to the Ombudsman for help.
That's right. It gives people another way to resolve grievances outside the court system.
What kind of complaints do they handle? Is it just about corruption, or can it be about other things too?
All sorts of things. Delays in processing applications, unfair decisions.
Yeah.
General maladministration.
So if you're stuck in like bureaucratic red tape, or you feel like a government agency has treated you unfairly,
Right.
the Ombudsman might be the answer.
Exactly. And what makes the Ombudsman unique is their focus on mediation and conciliation.
Okay.
So they often try to resolve complaints informally, bring the parties together to find a solution that works for everybody.
So they're kind of like a bridge
Yeah.
between the citizens and the government, encouraging communication and understanding.
Exactly. And it's not about assigning blame.
Right.
It's about finding solutions that address the problem.
Well, this has been a fantastic deep dive. I think we've learned so much about how legal systems around the world have created these mechanisms to address grievances and ensure accountability.
Absolutely. It speaks to this ongoing pursuit
Yeah.
of justice and fairness in societies everywhere.
We've covered so much today, from specific remedies in administrative law to these institutions that uphold those remedies. We looked at cases like common cause. We explored active state, misfeasance in public office, even delved into public trust.
It's been a great discussion.
It really has. It's so fascinating to see how all these pieces fit together to create a system that, while not perfect, it's always working towards protecting citizens and making sure that those in power are held responsible.
I agree.
This has been an incredibly insightful deep dive, and I think it'll be so valuable to our listeners, especially law students,
Absolutely.
as they navigate their legal studies and future careers.
It's a good reminder that the law is not just about these abstract rules.
Right.
It's a living, breathing system
Yeah.
that shapes our lives.
Absolutely. Well, thank you for joining LexTalks. Be sure to subscribe for more engaging legal discussions.